So I submitted a Freedom of Information request to the Petitions Committee in the House of Commons, and I wanted to know exactly, they're coming up with all these rules and then they've got standards of how the committees run and what they can and can't do. So I challenged them, I said, look, tell me what law the committee's running on, what legislation, what acts of law it's running on. What is the actual legislation that the committee exists or operates through, or what it uses as well. And they came back and they said a blatant lie. They said it doesn't use any statute or enactment, it doesn't operate through it, which is an absolute lie. And we're not just talking about the office itself, we're talking about proceedings in connection with petitions, right? It would be like saying to a court, what legislation are you running this court on? When you could say, well, the Magistrates Court Act, the Criminal Procedure Rules, the Civil Procedure Rules, there are multiple acts. And the thing is, with all the police, when the police submit evidence and then the court's directing the police to go get more evidence, or whether the defence or prosecution ask the court to direct the police, the court is engaged with investigation work and police work, either directing it or requesting permissions by either party. Because if you are investigating on behalf of the defendant, if the solicitor is doing the investigating work, the police are meant to be working for the public, but once they decide to prosecute someone with the prosecution, they're actually against you. But also, obviously, if you're claiming rights, or if they've got to recognise your rights, or if they find there's evidence you're not guilty, then they've got to supposedly change their position. But while you are defending, you can actually gather evidence for the defence, and you might need to subpoena evidence for the defence or get a warrant for the defence, not only for the police. Or if the solicitor's not going to go to a house to get evidence, then get the judge to direct the police to do it, right? But in civil cases, obtaining receipts from companies, in civil cases, you use subpoena and warrants and things as well. Now, the Petitions Committee, they lied and they refused to say that the committee does operate through the 1688 Bill of Rights, right to petition, because it's through that right that the people have got the right to lay petitions with the committee, and what comes with that. So they ignored that part. That is a blatant lie. Now, because they lied on that, I don't know if there's any other legislation or acts which they're also not telling us about. So you can't trust them with their response. But their official statement now is that this is all that they're claiming that the Petitions Committee operates on. This is it. This is all they are saying that legally the Petitions Committee are operating on, although they know very well that it operates on the right to petition, but they cared not to mention that, right? And there are other acts of law before the 1688 bill, like the Tumultuous Act and previous acts. Now, let's have a look at this. It is 145A, the Petitions Committee. This is a standing order, right? Which is different to legislation or law. But we know about standing orders because it mentions standing orders when we are promoting petitions, referendums and elections, and we've got a requirement to publish it to gather evidence of public support or promote them. In Class F, in advertisements and notices, in the Town and Country Planning Act, an advertisement required, that's the words, required to be displayed by standing orders of either House of Parliament or by any enactment or any condition imposed by enactment, well, you've got the right to petition, and the condition is that you shall not be prosecuted, and you cannot be held to any commitments, or any condition imposed by any enactment on the exercise of any function. Right? Well, you're exercising a function when you're collecting signatures. You're exercising a function when you investigate a police investigation or bring a civil case. Anything that is used through a legal process, right? Now, standing orders, required to be displayed by standing orders, well, the thing is, in court, you're required to submit evidence because that's through an enactment. The criminal procedure rules and civil procedure rules require you to file the evidence. A warrant requires you to allow the police access to your house, right? So that's law. Now, local councils publish advertisements to say that there's a road closure or roadworks. It's required to be displayed in at least one major newspaper. Now, in order to get a petition, you need to ask people, right? You need to ask people to sign it. If you can't ask them, you've been obstructed. That, you know. Now, petitions committee, besides standing orders, they've got directions on their website. Share this petition. Facebook, email, Twitter. These are both private sharing platforms, right? Published and affiliated with, in connection and in operation, parties, name declared parties that provide a function, right? A function, use the word function, a function in connection with running petitions, right? Now, so you're being given directions by Parliament to fulfill a function on private companies, right? And the committee operates by standing orders. Now, if you can't publish it, then you can't collect the evidence. When you collect witness statements, you're collecting evidence. And when you collect petition signatures, in the Inquiries Act 2005, the evidence is evidence of public concern. The signatures on the petition, you're collecting evidence like in a civil or criminal case, evidence of public concern, but you also can collect facts as well. Now, it's true that the court can direct the police or the CPS, they direct the case and they can ask for evidence. Or the CPS can ask for warrants and subpoenas, or the defence. How do you get your case into court in the first place? You have to gather evidence and lay it, right? Witness statements, or else it's not in the court. Then the court can, if more evidence is required, or if they want to, they can direct. Right? But you can ask. The court can direct a case, but if you say to your solicitor, there's evidence in this village at this house to prove I'm innocent, then the defence puts in a request for information access through subpoenas or warrant to access for the information, right? It's required. Now, traditionally, they had committees in the Parliament. This is the Painted Chamber where they had committees in Parliament, right? Now, the Tumultuous Petitioning Act, 1661, this is the rule. This is an act of law, This is an act, not standing orders, not just standing orders, not the right to petition. This is an act with petitioning rules and procedures in it, right? And even identifying what's going on. Justices involved in checking and actioning petitions, magistrates or a jury. This is a legal proceedings. There is no doubt about it. Now, we don't require magistrates or a jury or 3 justices to process the petitions when we submit them, because the petitions committee are responsible for doing it. It's the same thing. It's the same thing, right? Now, we know we're bringing petitions through the right to petition. You can't deny that, because that's what it concerns. That is the right of the subjects to petition the king or either House of Parliament, like it says in the Tumultuous Act. Unless you're only petitioning the king, I have petitioned the Queen herself. And all prosecutions for such petitioning are illegal. And as it says in the Claim of Right in Scotland, and imprisonments. Now, if that isn't an act of statute law which concerns the running of petitions, and that's how do you get the petition into the committee, that it's operating in connection with, then my name's Ridley Scott, which it's not. And it's not, my name's not Scott Benton either. Now, they won't produce or tell me any other legislation or law that they are running on. So this is their statement and evidence. So I challenged them on this, and they said, oh, your comments are duly noted. They never said that it's not running on the right to petition. Now, there are only 7 clauses here. It's hardly a full paragraph, right? This is literally what the Petitions Committee are claiming that they're running on. There shall be a select committee called the Petitions Committee to consider public petitions, that is cases presented to the House and e-petitions submitted. So all the ones that you hand into number 10 Downing Street or number 11 from 38degrees and change.org as well, go there. And e-petitions submitted through the House of Commons and Government e-petition site. Now, there is no law or rule or requirement by standing order here for the duration of petitions, right? And we know that because Laura, who did the tampon tax petition, took 8 months to collect 300,000 signatures for Paula Sheriff MP and with the backing of Theresa May. 8 months. That's not 6 months, right? So there is no 6-month time cap on petitions in law. Now, on their website, they say that e-petitions run for 6 months, right? And then you can't collect any more signatures on it. That doesn't mean to say that petition, you cannot have anything actioned on it, or you can't get any more signatures on paper for it, or anything like that. It says that it closes on the e-petition site of collecting signatures. It's still registered, it's still a case to government, it's still recorded, you've got a petition number, and it exists, right? There is no law for duration of petitions, none. They're saying that on their e-petition site, and it's not even a standing order. It's merely a direction for e-petitions. That doesn't say you can't continue it in paper, right? Or else how are all these change.org petitions being operated, like Laura's? So there is no duration. The committee shall consist of not more than 11 members, so it doesn't have to have 11 members, right? And we're lucky that it's not all completely Tories anyway. You know, really, you would have thought that Martin Day, the SNP member, was, you know, the only person on there with any integrity at all. But then again, can we trust the SNP party? You know, we definitely can't trust the Tories. Now, this is the important one here. This is the big clause here. Oh, well, and number 4. The committee shall have power, right? What power? It doesn't go into it in detail, but when it has power, you can't have a power in England without an authority or a jurisdiction in law or by standing order. Well, this standing order is giving power, but what power? What power? Through what enactment or law? They said that there aren't any other laws or enactments. So surely the power they've got can only be either through the 1688 bill or what's left of it, or the fact that Parliament itself does have a jurisdiction, regardless of whether it is in the Lords or the Commons or not, or they say they can't make judgments in the Commons or not, or refer it. But they have got power. They're given powers in this committee. Now, what are those powers? Right? They can send persons or send for persons. Well, if you've got power to send for a person and you use it and it's with a power, if that person doesn't have to come, or if you haven't got the power to send that person, you can't send them. You can only have a power to send a person if you compel them. Now, what's that? It's like issuing a summons, right? We'll write this down. If you don't have any power to fetch someone, you can't summon them. It's impossible. If you have a power to send for a person that is a power, then you've got the power to summon that person, right? Or else you can't summon them. You don't have that power. Papers and records. So that's information. So that is information's evidence, right? It doesn't say objects, fingerprints, or anything like that. But what is a record? What is a record? A fingerprint is the record of someone's finger printed on paper, right? That's what it is. It's a record of somebody's fingerprint, right? Being very, very, very vague, but you don't need to go in. If it's any records, then all and any type of records. Also, they can adjourn from place to place. It doesn't need to operate from the committee room. They're mobile, they can move. That means that Scott Benton and Martin Day can do their work for the committee at home or in his office. Or they can have another meeting room. The word here is adjourn. Adjourn. You don't adjourn a Christmas party, particularly when Boris Johnson's there. You adjourn legal proceedings, court, hearings. Adjourn. Why would you adjourn a sausage cocktail party? You wouldn't, because with powers in proceedings, you adjourn them, and to report from time to time. So they report on what they're doing. Now that is the critical thing. They have powers, jurisdiction to compel, to summon people, documents and records. But it doesn't say just for themselves or on their behalf. Can be for someone else. Now what does a judge do? A judge and a court have the person to summon people, information and types of records. But not just for their own leisure. They do it for a request of who? A request of, what are we in this court for? What are we doing sat in the court? Someone's brought a case. How did it get here? Someone's filed it. A plaintiff or a claimant, or the CPS or police or a private person. Could be a civil case for money, or it could be a prosecution or a private prosecution. And what's on the table at the court case? Did the court just sit there with nothing and say, someone fetch me some casework to do? What casework? Any casework? No, we submitted it. The work that they do is the work that we have filed with them. Now, Rishi Sunak has been saying recently that he wants to give the government powers to look at people's bank details, bank accounts. Now, the Petitions Committee has already got powers to look at bank accounts if it was in connection with a case filed to them, if it needed to be for someone's petition evidence or debate. If it's not, then they can't. So they'd have to say that it was for the purposes of the case they're looking at. Although MPs can file petitions and their pals and their corporate buddies, oh, what a coincidence, we need to look at so-and-so's bank account. Well, here's my friend from the bank, got in a case that, we should change banking rules. Oh, well, let's have a look at some of the work you're doing then, oh, well, now we can look at it magically. Obviously, a court, if someone brings in a case to get divorced to a court, they've got no reason or right to start looking at the, Greg's Pasty Shop's bank account, because it's got nothing to do with Mrs. Dibblethwaite getting divorced in Johnny Groats, has it? So why would they be requesting paperwork for that when it's nothing to do with it? But they have got powers if it was something to do with it, right? So when we ask them, excuse me, I would like to obtain these papers or records for the evidence for the petition, even to say that it's worth you looking at, right? Now, if the Petitions Committee want to look at it and direct it, fair enough. But how do they know in the first place there's a case worth looking at if there isn't any papers or evidence at all? You need something. And what if you can't get hold of that something, or someone's obstructing it? But also summons of persons, and this power, surely it can only be the summons of persons. And to obtain the information with a power, you are subpoenaing it. You're subpoenaing the information. It's a subpoena. Or to go and look for it if it's in private property with any power, else you don't have power to do that, is a warrant. It's a warrant to go and get the papers or records. So this is, without doubt and without question, this 145A Petitions Committee is giving the committee certain restricted powers of court, limited powers for investigative purposes. Now that is bringing us on to this, number 4. The committee shall have power to appoint a subcommittee. So then they've got another committee going, which shall have the power to send for persons, papers and records to adjourn from place to place and report to the committee. So besides, because there's only 11 members and they've got limited staff, they're saying that it's only a small working jurisdiction office. But they can set up other subcommittees to deal with matters if they're busy. But there will be limits on the size of these subcommittees, right? And they've got to report back to them. So basically they're saying, here's something worth investigating or looking into for whatever of these above reasons, whether it's debate or getting an action through another part of government. It doesn't have to be debate, or even a public inquiry, which I'll get onto now in a minute. So they can set up, appoint a subcommittee, but it doesn't say subcommittees. But it doesn't say whether that it shall have appoint a subcommittee for each petition or each matter. Now, number 4 is important because really this is what the role of the public inquiry itself is. The Inquiries Act 2005, which is updated from the Tribunals Investigations Act, it creates a limited temporary court that has a chair and members of a board, and they will direct investigation, and they're given powers to the same effect as 3 here, to send for persons, papers and records, right? And they can question the people. They can't make orders, convictions, or make orders for money or convict people. But if they find there is any crime or evidence of wrongdoings or civil matters that need a judgment, they can refer the matter to the High Court to deal with it, right? Now, the Inquiries Act is for very big matters like Hillsborough. It could go on for years. It could have a lot of evidence and investigations. Far too big a matter for this committee to deal with, or its subcommittee. It's so big and serious that even the subcommittee, the submarine committee, cannot. It's too big for them to deal with. The powers are very similar, and they're expressed and written in an act of law in the Inquiries Act. And all witnesses have immunity as well, by the way. Let's not forget that. Now, even with the Inquiries Act, anyone who's involved in the inquiry, the chair is directing it, but who brought the case? How did it get into inquiry? Someone asked for it, or a minister asked for it. Either the minister asked for it or a person asked the minister for it. They are the claimant, and if they brought the initial evidence and the minister actioned an inquiry, they still are the plaintiff, the claimant, or the person who brought the inquiry. They are the primary witness, the first witness. The victim is usually always the first and primary witness on the side of the prosecution, unless they were asleep and, you know, they got raped while they were asleep and they didn't witness it. Someone else did. Then they didn't really witness anything other than saying that they were or were not somewhere at a time. If they'd been blind and gagged and blindfolded and moved around in 10 vans from place to place, they wouldn't have a clue where they were. They wouldn't be a very good witness other than all I can say is I don't know what happened for the last 3 days, right? Someone else was a witness. But usually, under standard conditions, the victim, or if it is a civil case, the claimant for the case being brought is the first and primary witness on the claim. And then you've got the witnesses on the defence, right? Or the respondent's witnesses, or the defendants on the defence. Now, this committee, the standing orders are written very simply, briefed, but they are written to mean something. It doesn't need to say, and the Inquiries Act shall give the committee and the powers of, summons and blah, 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 right? That's an act of law. This is a standing order, but it's giving them powers, right? If you haven't got a power, you can't enforce or compel anyone to do anything. It isn't power, right? It isn't power. The committee shall have power to report from time to time the evidence taken before the subcommittee. The quorum of the subcommittee shall be 3, right? That's almost like 3 justices, isn't it? It's almost like if the quorum of the subcommittee shall be 3, then it's almost like 3 justices. And if the committee are setting up people to deal with matters that have those powers as well as the 11 committee members, then it's literally the equivalent of in the Tumultuous Petitioning Act when you've got Magistrates of London or 3 justices or a grand jury. And it is the grand jury when everyone's signing it on the petition site published. Now, well, it's effectively as close as you can get. The committee shall be responsible for determining whether a sitting should take place in Westminster Hall under paragraph 1A of Standing Order number 10 to debate sittings in Westminster Hall, to consider one or more petitions or e-petitions, but an e-petition is still a petition by definition of the 1688 bill, and by even though we're not using the 1661 bill, it still qualifies for the definition of what it is, and shall report any such determination to the House, right? And let's not forget that any minister, including these 3, if they are ministers, or the 11 ministers, can initiate a public inquiry through the Inquiries Act from a petition. if there's sufficient evidence, and if you can't submit the evidence and attach it to the e-petition, you're going to have a hard time doing it online. Particularly even if you link to it and they say that they're not going to publish it because they don't want to publish the link. Although it doesn't say about paper ones. There is no... The legislation or statute for 6 months petitions running is not a law. It's guidance, and it is merely it's equivalent. It's not even a standing order. It's not a condition imposed by enactment. In fact, the only condition imposed by an enactment, which is relevant to petitions being run in this committee, is this. There is the right of the subject to petition the king, and all commitments and prosecutions are illegal. Well, there aren't any commitments in the standing order 145A. There aren't any commitments for us, and there aren't really any commitments what was significant and here in restrictions. So they just set up the e-petition to run for 6 months because they conjured it up, right? Doesn't mean petitions can't run for longer. It means they only run on the website and then they turn it off. Doesn't mean that the petition itself can't continue. There's nothing to say that in law. Now, I've just had to switch my phone because the battery was going on the other one, so I've had to get my other phone now to continue. It looks a bit lighter actually now. So, there is nothing in law, no standing order or enactment or statute that says how long petitions can or cannot run for. It is a direction at the most, right? Now, this is where we are getting failed by the people we elect and we vote to represent us in government. And this is where the political parties are not only abusing their positions and authorities, they are disarming us to be able to do law. I would say it's perverting the course of justice. When we look at the dictionary, the word justice in the dictionary is due process in law. It is the process of law. So that is also civil, criminal, and political. Because after all, when we're adjourning and when we've got powers to compel summon people, we're dealing with law, even if it's the Inquiries Act, if it's a limited jurisdiction, a special jurisdiction, right? This is a special, exclusive, limited jurisdiction, right? Although the House of Lords is meant to be able to make judgments. Apparently it doesn't anymore, and it didn't have that power through the Appealate Jurisdiction Act either. It has it because it is in the nature of the building place and people in there. So now this is where we get into very serious matters over perverting the course of lawful due process, either by lying and not telling the truth, failing to admit that people who are being petitioned to the committee use this right and the committee is operating on it. Now, we're talking about publishing now, right? This is a book. It's actually about your rights. And this is the painted chamber on the back of it. From Parliament, which is where they used to have committee meetings in the 1600s. Now, in order, right, for any civil casework claimant, right, to bring a case to a court and to hear it, or any criminal case, whether it is private prosecution or the CPS or police, right, you have to have something, anything, a Sainsbury's receipt. This Sainsbury's receipt could be all you need. If you were in a shop and you stole a supermarket trolley full of food and the security guard arrests you, I know that apparently they don't pursue petty theft anymore. Let's say you had a full supermarket full of food and you've been prosecuted for theft, but you paid for it. This bit of paper, right, could prove you not guilty if you paid for it on your bank card, right? Now, if you don't have this bit of paper, if another person has it, and you know who has it, or you need to get it from somewhere, like it's locked in a sports centre locker and you lost the key, you need to get it. But you don't just need to get it for any old reason. You need to get it because it is required through lawful due process, right? In fact, you might have been summoned with powers. Now, if you were anyone, you would just bring this into court, right? If you got to a stage where you didn't have it and you were in the court, then the judge or the justice, if you tell them where it is at the sports centre in the locker and the clothes shut down, but you know who owns it, you might have to subpoena it or summon the owner, the person, right? But without the court doing it, if you could get this and just ask him for it, and let's say he give you it, excuse me, I need that receipt, it's in locker 346. And then he just says, oh, sure, no problem. I'll go in with you on Tuesday at 4:30. I'll meet you there. I know it's shut down now, but we'll go in and get it. And he goes and gets it, and he gives you it, then you've got it, right? Now, if your court case is in a month, then you or your solicitor ask the court, right, for a subpoena for it, or you say that you want to summon him as a witness and you fill in the forms to do it. Now, for criminal and civil procedures, they've got the criminal procedure rules and the civil procedure rules for two different types of court. Are there any procedure rules for the House of Commons Petition Committee when they are not adjourned, when they are in session, not adjourned, when they are in a session using powers? For what? Powers for what? Powers to do what? They don't do anything unless we have brought it to them and listed it. It's all about our cases. Unless Martin Day and Scott Benton just sit there all day with their business partner from Amazon who's submitting cases that are convenient to the pursuit of enterprises, and that is the only thing they're using the powers for, conveniently using the Petitions Committee for the ends of political party agenda and their pals, maybe even the investigative powers to look at people's bank accounts. That's it. We could just conjure up I'll petition on this. It'll give us a good excuse to have a look at the butcher's accounts, if we think, the tax on butchering should be changed. Like tampon tax. We'll change the tampon tax. Let's have a look at some accounts from a few tampon shops and we'll see what their profits are and if it merits changing the tax. There's an excuse to subpoena the accounts of a tampon shop or a chemist to see whether or not they think that they should merit the tax change. Cleverly fit into the casework, If it's not got anything to do with that, then they've got no reason or right to do it. Apparently, in a lot of these Extinction Rebellion cases in court, they go off subject too much, and the judge says, oh, it's not relevant. It's not relevant to what we're doing. There couldn't be anything more relevant. There couldn't be anything more relevant to 145A3 than persons, papers or records concerning your petitions. If you've got the records and if you can get the persons or papers, and records can be digital records. Let's have a look at this. When we're publishing petitions and when we're advertising or promoting them, in order to collect evidence of public concern, similarly as set out in the Inquiries Act, Part 1A and B, which is near identical to this process, evidence of public concern through the publication of the petition on Facebook and Twitter. If you can get on there, if you can get access to there, which this law grants you not to be held to any commitments by these places that you're being published to. Otherwise you don't have any power to publish. You haven't got any power to publish to even get the signatures on the websites. If you can't publish them on there, you can't fulfill the function. You can't exercise a function of petitioning if you can't publish in the newspaper, in the public notices, or if you can't walk around in the streets asking people. You can't serve a function, right? Now, normally you just ask people, but you've got a right not to be held to any commitments. In America, they've got the First Amendment, which is petition, freedom of speech to petition, ask, and in the press to publish. This gives the requirement to publish like any notice from the government because it's for law. Because you're bringing a case and law gives you the right to do it. And if people do not comply with the law, persons or documents, of the jurisdiction or authority with who the case is filed with, which is the Parliament Petitions Committee, then can ask and compel people or records or files. Advertisement means any word, letter, model, sign, placard, board, notice, or in a blind device or a legal representation, whether illuminated or not. Well, what am I recording this on? An illuminated phone. Right? Records on mobile phones, digital, illuminated. Now, what happens if you can't access your petition? What happens if you can't access your petition itself? What happens if somebody takes it off you? Right? What happens if they seize it from you? When it's your petition and it's between you and a court. If you have got your court case files walking down the road in Leicester and you're on your way to court and someone steals them off you, how do you get them back? Now, 38 Degrees, who choose to deal with live petitions to the government, it's not their petition. They are publishing it on their website. They're taking people's petitions down and making their own judgments on what signatures are valid or not valid, and even actioning in your private messaging, and even not even letting you have your full data, right? 38 Degrees, as far as I know, are not being appointed as a subcommittee, unless they show me evidence that they are appointed as a subcommittee that is from time to time operating from 38 Degrees. And if they were appointed as a subcommittee, 38 Degrees, why do we have to download the petitions and take them to number 10 or into the local council if they are acting under the powers to make the decision whether it should be debated themselves, which they aren't? And if they were appointed as a subcommittee at 38 Degrees, then why aren't they summoning people, persons or papers from us, for us? Why aren't they asking for evidence and records? And why aren't they telling people to put our advertisements for petitions back up on YouTube when it is serving a function of lawful due process? Because it's required, whether privately owned or not. Because you can't be held to any commitments. And all companies have a certificate from Companies House with a coat of arms on the top. Company number. They're only authorised to be a company under the conditions of the Crown, which is they have to grant people their rights and privileges. If you don't want to grant people their rights and privileges in petitioning, you're really in the wrong business if you're running a petition website like 38 Degrees or any sort of media or publishing, because you've also got the right to access printed material as well. There might only be one printer in a village, and when there's an election on, if they deny printing services to someone who's running for election, that is also, they're trying to hold you to a commitment, and you are unfair. You are not going to be able to access services, particularly if they're not VAT registered. They might not have a company certificate. They're only small, but still, they shouldn't be turning business down. Now, this is the thing with YouTube. Also, when we're publishing, right, the word publish, we've had the Jimmy Dore show going into this with this Kurt Metzer guy talking about the First Amendment and what is YouTube, what is a book publisher, and they're trying to differentiate the difference between it doesn't matter what type of organisation you are or how it's formed or what it classifies as. Simply by running this through the printer and making it available, no matter how many copies of this document, this piece of paper here, whether I print this one copy and put it on the notice board at the sports centre or in the town centre, or whether I make 500 copies of it and give them to every house in a village, right? In concerning local referendums, and I would say elections and petitions, it has to be, the word publish means make available to the public or a section of the public, right? Means make available to the public or a section of the public, right? Merely make it available to them. Why? Because it's like a witness appeal. Because in the Inquiries Act, when you are asking for an inquiry, right, you've got 1A and B. Evidence of public concern, which would be the public themselves saying they're concerned in writing or by statement, or not just a newspaper claiming that there's public concern. A newspaper could publish a story saying, oh, everyone's concerned, but how do you know they are? If a newspaper publishes a story saying, oh, everyone's concerned, did they ask them all? Or did the newspaper reporter just write a story saying that people were concerned and publish it? And then the police chief says, oh, everyone's concerned about this. How do you know? Has the reporter told the truth? And, where do they get their statements from? That's a newspaper story it's only part of some evidence. It's a claim of evidence, but the actual evidence that the public are concerned is from the public themselves, if the police have got multiple complaints. Or just the evidence itself. If you've got a survey from a science lab which says that, 10,000 people are dying, and that is meant to be a factual recorded survey that they asked people and they documented it, that itself is used as evidence, whether you can obtain it, if you can get access. So they will be trying to use their own policy or their own rules to prevent you making it available to the public or a section of the public, right? Now, Parliament, the Petitions Committee, who have got the powers to summon people, it's not only obtain papers or records, it is for those petition papers and records to be displayed or shown, right? Because if the private company Facebook, Twitter or 38 Degrees has got the information and the records, if they've taken it down and removed it or are withholding it, they are not giving it over, but giving it over to who to send for persons, papers or records, to send for them where? To send for them where? Just to them? Or to send them to the public? To send for them to the public, because then you're not, for this legal process, you can't be held to any commitments by the private companies for this class of material, class F, which the advertisement is a legal representation. The advert is a legal representation. So for the committee with powers to summon people's papers and records, how do you get the paper and record if the person doesn't comply? You haven't got power. It has to be a warrant to go in and look for it, or a subpoena to give it over, right? They can't make a court order, like a judgment in a civil case, pay someone £50. Now, these powers that are used for investigative proceedings, controlling and obtaining people and evidence in pursuit of an investigation or inquiry, not a final judgment or order like in a court, like the Inquiries Act. Now, when you publish a witness appeal, an appeal for witnesses, asking for witnesses to come forward in the newspaper, witnesses who might want to appear in a public inquiry or Parliament might need to send for. How do they know the persons exist, or whom or where the persons are, if they cannot publish an advertisement to ask for them to come forward, or us who are bringing the case to ask the public for evidence of public support, witness signatures and statements that they agree with you, in order for the debate to take place? You can't have it, because it's obstructing the pursuit of persons who you may wish to summon with the papers or records, or just give statements. It's got nothing to do with an order at the end of a case or a prosecution, which can be referred to a criminal or civil court, or the House of Lords can make judgments even without the Appeal Jurisdiction Act, but they're doing it in the Supreme Court now. Now, if a public inquiry through the Inquiries Act, it is, I'm telling you, it is the same powers as 145A4, 3 and 4. And if you've got a public inquiry, they can't make judgments or orders or convictions. That's the civil court. But how can they call for witnesses for the Hillsborough unless they put an advert out and ask them to come forward, or publish it on the government website? They can publish witness appeals. It's a petition in the newspaper, a representation. It is a witness appeal in connection with legal proceedings to the Petitions Committee. And you can ask them in the same way you ask at an inquiry or a court for a subpoena or a warrant or summons, because they aren't judgments being made. They're required for the function of the investigation or of the proceedings. Now, the Petitions Committee are choosing to hoard and selfishly use these powers for themselves, when otherwise you might not be able to file the petition with them if you don't have the information or evidence. Sure, they can decide whether or not to issue it. They're trying to claim they can't do it when they're lying, or you wouldn't need to do it. If you can't publish with this law in connection for a function, exercising the function of the right to petition through the Town and Country Planning Act in the newspaper with a legal representation, a witness appeal for witnesses who support the petition. If you can't publish it, you can't get any witnesses and you won't know who to summon. This is the critical thinking and intellectual reflection that is missing in school teachers, as confirmed by Lawrence Fox on his Reclaim Party video with the head school teacher, who's saying that even school teachers aren't meeting the intellectual capacity that is required to understand this, and when pressed on it, they don't want to discuss it and they switch off, like what the Petitions Committee are doing. Now, Martin Day MP, he needs to decide, as a Scottish National Party member who is not Tory or Labour, he needs to decide if he is actually elected to represent the public on the Petitions Committee in their casework, and if he's going to use his powers when they ask and request it, if it's reasonable or required, primarily when they can't get their petition shared on Facebook or Twitter or YouTube because it's been obstructed, because the policy, no one's broke the law. Tell me the law that's been broken. None. So why is it being removed? And the worst thing is, why are 38 Degrees conducting themselves when they specialise in petitions that are operating under this statute law? They're acting as if they are a subcommittee of the Petitions Committee. When how can they be? If they are, why do I need to submit the petitions to number 10 or even the local council? Because they're not a subcommittee and they don't have powers to edit, censor, reject, look at private messages, private legal communications, or anything like that, or not give you your own data that's data protection when they're protecting you from your own data. We've got serious problems in this committee. There is no actual law that they can give to me in place, right? Now, when my petition number, whether it is, 93182, right? That is my case, legal case. I haven't filed that case with the Magistrates Court. I haven't filed that case with the Crown Court, and I haven't filed the case with the Old Bailey. I filed it with this committee, who are the responsible authority, not the public inquiry, not the Magistrates Court, and not the Crown Court. They are dealing with my case management, and I need to publish the witness statement, the witness appeal, on the sites that they are affiliated with and working with, published on their site that they tell us to use. They're refusing to use the powers so we can ask for these persons to come forward and sign petitions, let alone give any further evidence. And the petition is a record of signatures. In the VAT rules, we've got election addresses. is an election address if it isn't the addresses of the people in an election? Now, God knows what's happening with the polling cards. You can have poll cards that are not political poll cards, commercial poll cards, right? Why is every poll card concerning an election got the address on it of the people you're sending it to? So why are they registered as not VAT 0 rated in the tax rules for printed matter when election addresses are? And handbills! A handbill! Sign my petition! It's a handbill! An advert for the petition, a representation, 0 tax rating! Why are we getting taxed by the London Evening Standard for publishing handbills and adverts that are addressing the public concerning elections? We're paying tax on things we shouldn't be paying tax on. The committee is responsible for powers, compelling persons, papers and records in connection with petitions, not just collecting, but in securing the function, the exercise of the function, the exercise of the function through the enactment. Through the enactment, they claim that doesn't exist. It's like Americans saying there is no First Amendment. There is no First Amendment. There is no right to petition. Either House of Commons or the King. Rubbish. And I have petitioned, I sent my petition to the Queen anyway, concerning my petition, my case number anyway. So we've got Martin Day MP is public enemy number 1 at the moment. I mean, with Scott Benton, the name says it all. With the Tories, I can understand the corruption, the pure corruption. It's like if you went to a court and the criminal who stole your car was the judge, or even 3 criminals who stole your car were sat there judging your own case, they're not going to want to give you any help or assistance or use any powers. So there's a reason why the committee is made up of people from different parties in the petitions committee. It's meant to be fairness and balance, so that it's not a situation like if you went to court and the person you're accusing of stealing your car and their friends were the 3 justices. It's meant to be so if you bring a petition to Parliament, it's not as if you were getting divorced to your wife and her friends were the 3 justices who you were getting divorced, because then fair trial is impossible, and even fair investigation, which is why the committee is meant to be made up of members from different parties. Now, we elect them to run that committee is a public service. And in order to function as a public service, it needs to be offering and actioning a function, right? It needs to exercise a function. Exercise of a function that you request. Now, there aren't any procedure rules for the petition committee. You don't have any. But they've been given the powers. So all you do is you make a request. As long as you have your name, what you're asking for, your petition details number, and the details of the person, it should be quite simply enough information that would be sufficient to fulfill the same or similar function for criminal or civil request for a warrant or subpoena or summons. And that is just sufficient information. I don't know how they do it in the Inquiries Act, but it's usually the chairman. Who is the claimant? Well, I still believe that the person who called for the inquiry in the first place is, and they usually, you would have thought that they would be called as a witness, but maybe they're not needed. But in order to get this is the thing. You are engaged in proceedings to get a debate or to even get an inquiry. So a lot of times petitions are rejected on the e-petition site because there's insufficient information to inform or compel the ministers in the committee. They restrict and inhibit the amount of information, and they will not attach evidence. They are making a very weak case online. A very, very weak case. In fact, you could say it's been designed so that you cannot bring a strong case in anything. And by paper, well, depends how detailed you want to get, because according to the Local Governments Act, you can petition for a local referendum and you can suggest how it will be run and how the local referendum will be run and through what the procedures will be. So you could even suggest that for a petition to Parliament claiming that they have no more, they're not claiming any more rules than these. They're not claiming any more standing orders. You could probably draft your own petition and how it will be run. They're running e-petitions over like 6 months, right? You could write a paper petition saying that you want an e-petition that lasts for 12 months and to extend the time. There's nothing here to prevent that from happening or to say that it can't be done or to reactivate a petition, because that 6 months, we know that in law, following the tampon tax petition of 8 months on change.org, it went through no restriction at all. And even if you would have thought that even if 38 Degrees were running on a subcommittee, or were a subcommittee, that their petitions would run for 6 months as well, which they don't. We are being hustled by these political parties who really don't want a fair trial. It's almost like how the national lotteries run, where it's all pretended to be good and happy and you could be a winner, but the petitions you submit are joke, like the prizes in the lottery, but it's all going to a good cause, all going to the Tories or Labour, and occasionally you might get the 100,000 signatures if you're lucky, but what do you get out of it? If you're lucky, you might get a debate and no one turns up. It's like when I won the jackpot on the scratch card full of 500s, and I got £500 they gave me for handing it in, when the card cost £5 and the odds in finding it were 40,000 to 1 odds. So if I'd have bought 40,000 cards at £5 and I didn't find it till the last card, it would have cost me £200,000. So that card is worth £200,000 to me as an art piece, as a valuable, rare item that is very difficult to obtain. Yet Camelot only gave you £500 reward for handing it in. You didn't have to hand it in. I could have kept it and sold it to a gambling collector, right? And this is what my claim is. They took my card off me and only gave me a photocopy of it and wouldn't give me the card back. Yet the previous director, before Nigel Railton, sent me all my cards back when I asked for them and gave me the cheque with the money. So I had the memento of the card and the money. Yet the money, in this sense, the prize that they want to offer you for finding something which is extremely valuable and could cost you up to £200,000 to find, he only wants to give you £500 for it. 100,000 signatures isn't easy to get. Unless you've got a very, very big... Some people can get it easily now due to social platforms and followers, but they're even trying to restrict that now, and that is why we can't even get the petitions published through here, because the platforms are controlling who's popular, who isn't popular, and who can click their fingers like Chris Packham and Neil Oliver and get 100,000 signatures every day. Right? And that is an abuse of process that we're not even allowed when we're being denied it and we're struggling, but yet there's potential people to support it out there. They're not helping us. We have got these powers, and those powers are being denied us. I will accept that Scott Benton and Martin Day are not intelligent enough to understand it. I'll accept that they're being misguided and misled by the ministry or by their advisors. I will accept if they plead that they don't understand it. But I will not accept lies. They have got these powers. It doesn't only cover bringing in evidence, but these powers... they're not judgments. These are powers of facilitating investigation and to facilitate the to send for persons, you have to be able to air a message that you're looking for them and that you want to shout out, are you out there? Are you out there? Right? And you can't do that if it's not published on the website that the government are saying use in conjunction with the website under their directions to serve that function, which is here. That is, this page of the Petitions Committee operates with using the Town and Country Planning Act in digital form. And the Petitions Committee are telling me they're not operating that committee through or using any legislation. When it's here, they publish it on the website, share on Facebook and Twitter. How do you do that? Because it's a Class F legal representation through the Town and Country Planning Act to exercise a function. Why are we electing liars? Why are we electing liars? If Martin Day and the SNP do not, Martin Day has got the authority to tell YouTube to restore my witness appeal. I am collecting signatures from witnesses who support my campaign. And in the newspaper as well. And the tax on that, we're not getting any help. Now, the committee doesn't deal with tax, but when they are telling you to promote your petitions and share them, when you're getting them printed, it is something in connection with the case you're running with them when you're printing your materials. And if you request a letter from them to a company you're buying leaflets off to confirm that you're tax exempt for the printing of your materials, your adverts, your handbills, your election addresses, then they should write you that letter. Even if it's one sentence to say, dear sir, we will write in petition number blah, 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 to confirm your tax exempt status of your printing of your leaflets. They don't even want to help you with that. when people are writing freedom of information requests all day. It doesn't take much. They don't want to help you, and it's not even it's not like you're asking them to go collect signatures for you, or design you a leaflet or write your petition for you. In fact, sometimes they write out a suggested petition. We suggest you word your petition this way. They don't want to actually serve their intended function, which we are paying for. We are paying national insurance for their wages, and we are electing them. Martin Day needs to do something about this committee, and the chairperson is responsible, and I'd say the Prime Minister. Now, I want them in the Supreme Court prosecuted for perverting the course of justice. I want them in the Supreme Court prosecuted, MPs, or by the Select Committee for the Privileges Committee for perverting the course of justice. Or if they don't start doing their job properly. I just also wanted to give one final kind of point on it as well, additional point. I know it's kind of gone on a bit this video, but the 10,000 signatures that you get for a petition, that's 10,000 people supporting a cause or agree with something you put. It's a lot of people, 10,000. They're not all going to be stupid. You can't have 10,000 people without getting at least, a few academics in there. When you get 10,000 signatures and they give you an official response, an official position or statement from Parliament, you really are getting really, really fobbed off with that. It's kind of like, when I said winning the lottery and getting a card that, is 40,000 to 1, and it's very difficult to get it. But what you receive for that is only £500. It's a very, it's not even a commiserate, it's not even like, it's not even a booby prize. And I know that what makes it unfair now is that with social media, that some of us are actually trying to get us rights to get onto social media that the Petitions Committee are meant to be backing us up with, and certain other requests. Some people have got a hell of a lot of what you call followers or fans, like TV programs used to have, but TV programs didn't used to be allowed to get involved in politics. Now, a person can get 10,000 signatures quite easily, but another person can't. But there might be people who support them, but you've got to go around begging, and it takes time, and it can be disappointing. So the public aren't being represented. The public are being unfairly treated because some are privileged. Some have got the privilege of, 100,000 followers, and some haven't. It's almost like being born with rich parents or not, but socially. I know that not always people support you politically. I mean, even John Campbell, but when you've got so many people who are following your channel, you're always going to get quite a lot of people who help you or support it anyway. And for that reason, I think that Parliament really don't value 10,000 signatures. They definitely don't value what 10,000 signatures is worth. When you only get 12 people in on a jury sworn in and they decide in legal cases on criminal matters, like Extinction Rebellion, the committee don't really value public opinion unless it's their own election. And then the other half of the people aren't voting. There's only a very small number of people they get elected through. They really value that then.
But when we're getting petitions signed on specific matters, they really devalue it and they don't appreciate it. And some people are taking it for granted, and then just, people aren't being given equal resources to pursue it. Really, these powers that the Petitions Committee really do have for summons and subpoena and, data information, it does extend to publication when it's in the investigative phase. Anything to do with running petitions. Now, the only things that petitions can really concern, other than handing out flyers and asking people, is print publication, whether that's online, digital, or printed. And they ask you to do that on their website. They even associate and affiliate with these websites. And then they're using 77th Brigade to take things down, but then claiming they won't enforce and put things up. And they're refusing to use these powers, and they're even trying to say they don't have them when they're clearly there for that purpose. They're there for our cases we're bringing at our stage as well, if we want to apply for them. And 10,000 signatures should more. I mean, a jury in a criminal local case with 12 people sworn in has never seen 10,000 people signing or supporting a political cause which might compel Parliament to summon someone, or even ask someone, or even get something put back up if it's been taken down, when it's for due process, when it's to serve the function. And that's even how you can get 10,000 signatures. So once you get 10,000 signatures, I mean, really, if you want some further information, it's all, we'll get the information, we'll get the details, whatever. Fill your 50 words in or whatever. Yeah, you can do paper petitions. In a way, it's all wrong. And the fact there is no procedure rules for it, when it could be over very serious and grave matters, like, the World Health Organization taking his rights away, or if you want a public inquiry, which is a lot bigger than a court case, a civil case or a criminal case. We're being treated like the National Lottery treat people. They want the money, they want all the money, and they want people to vote for them, elect them, let them sort it out, let them deal with the charity money, let them use the charity money. And then when you do something good, you get some good information or report something into the government concerning, whether it's something really been government wrongdoing, when they kind of say that you shouldn't really be petitioning about that, when we should. Public inquiry into, Hillsborough or whatever it is, or, if you get something that's quite good and valuable to the people, but the political parties might not like it, they're really leaving us out of being able to request for powers. Now, powers exist because it's legal proceedings. Powers exist because it's official. Powers exist because it's important, and powers exist because you're collecting 10,000, 100,000 signatures and publishing it in the newspaper. We have a right to those powers, to ask for them to use them. And they are absolutely taking the mick out of us with a 10,000 signature mark. And even with the 100,000 signature mark, if you get a debate and no one turns up hardly, like 10 MPs, like some of what Andrew Bridgen, it really is undermining, and the devaluation of what you've done to achieve that. Even whether you've got, 1 million followers and you can do it like Russell Brand with a click of your fingers, or whether you had to beg for them, if you're getting you're not getting your tax taken off your material you're getting published, and you can't afford it, it's not about claiming it back after. You're not VAT registered as a company, but you got a petition number, and you're printing handbills that are advertisements. It's zero rated. If they aren't going to make any effort to write the slightest letter when they're, they'll write a suggestion for a petition, or they'll do a freedom of information. They can't be that busy. They won't go to the chairman of the committee to get approval for a tax status confirmation for your printing of your leaflets. They won't help get your YouTube channel back up. They won't go to the newspaper, for you. I did my own legal representation with a newspaper for right to publish and won. And if I've got the power to do it and make the representation for right to publish, quoting the 5013C illegal campaign intervention and the Class F materials, then the petition committee can do it. It's correct. The newspaper agreed. They're not interested. They only think that they use those powers when they want to direct them on their own initiative. Now, in lower cases, very small local cases, solicitors, barristers, claimants, plaintiffs can use initiative and the law to ask for orders, not an order or a judgment, but through the proceedings, other powers. Now, these powers have been selectively isolated for public inquiry, or else you can't proceed. You can't actually do it without the powers. And if the Petitions Committee didn't have the powers, then they wouldn't be able to do what they're doing. But they're being selfish with them, and they're being party politically biased with them, and they're being unreasonable. They don't want to help us, but it's not like helping your cause. It is the function of it. It's what it's there for. The judge isn't asking the jury to decide in your favour, or even judging in your favour anyway. He's got to facilitate your ability to bring in evidence, to obtain things. And that's required in proceedings for all parties. And he's not always in complete control and direction of the case. Your solicitor makes requests via the procedure rules. At this point, we'd like to ask to subpoena some evidence, or obtain a warrant, or summon witnesses, right? That's not anything to do with making a judgment in your favour or against. If you can't have those powers, you can't operate. And we have a right and initiative to enter requests for that. And the Petitions Committee are playing dumb. They're playing dumb diddly dumb, or they are blatantly and politically party opposed, and they shouldn't be in the committee. Because it effectively, if you were suing the Conservative Party in court, the party, for something, let's say you could sue them, they're claiming immunity. Well, Lawrence Fox was taken to court. Then you don't want a judge who would be a member of the Conservative Party. Really, it's not good. You don't want a judge who will be the leader of the House of Commons, or the political party leader, or a big donator to the Tories out of his own money. Because effectively, you've got a Tory there when you're trying to prosecute them. Now, if you're asking for subpoenas and warrants and things which will prove the Tory Conservative Party a criminal if you sue them, what if the judge is going to refuse it on the basis that he's a party political member? Now try that on with the Judicial Conduct Investigations Office, right? Now the problem is with Lawrence Fox, with the Reclaim Party on GB News, when he was talking about ULEZ, Stop ULEZ campaign and the Blade Runners, the police brought charges against him. Now, the police commissioner, Rowley, Mark Rowley, Sir Mark Rowley, is a knight of the realm, taking orders from the king, right? He is a commissioner of cameras who has an interest in council meetings with dispatching representatives to try to talk the council and Sadiq Khan into having more cameras. And government departments have said they want facial recognition employed on them. He is sending a police representative in a council meeting to get cameras fitted. So he's got political engagement with the council on behalf of the police, and he's commissioning them, right? Yet he's sending his officers to arrest Lawrence Fox, who's a political party leader who's opposed to them. Now, if Lawrence Fox, let's say the police chief ends up sat there being a justice of the peace, and Lawrence Fox wants to subpoena evidence to prove not only that he's innocent, but the cameras are unlawful. Now, is that fair and right for the police chief to be there? Like when I was in Manchester and there was the spitting image of Sir Peter Fye sat in the courtroom behind the head magistrate, head judge. That looked suspicious when he looked like the spitting image of Peter Fahey. It could very well have been him, because I've never seen anyone who looked more like him in my life, unless it was a joke or a comedy sketch or some weird set-up treatment or mind game, right? Who's registered to have been the head magistrate at that time? Now, that's just an example though. I can't prove that that was Fahey or not. But if the person commissioning the cameras into use, and you are in a petition campaign opposing that man with signatures, he can't judge your case or petition. Now, if you've got someone in the petitions committee who is effectively, on his side, pro his side, you've got a problem when you're wanting to, if your videos are getting taken down from YouTube, if you can't publish things in a newspaper, you've got problems. Or if you can't obtain evidence from one party or the other, and you need to get it compelled to be taken with your own initiative for your initial paper or e-petition. And we're being conned. Now, they can carry on playing dumb for so long. You can only pretend to be stupid for so long until people realise you're pretending to be stupid. And when people realise that you are no longer stupid, that you are a liar, and you are deceiving the public and perverting the course of justice, then you are a criminal. And you need to be taken to court and prosecuted, not by the Petitions Privileges Committee, but in the Supreme Court, as a criminal crime of perverting the course of justice as an elected MP. It's not for the Privilege Committee. You need to face criminal charges in a court of law at whatever level it is, because you can't be that stupid to... All my problems at the moment are because actually of this committee, the Petitions Committee, of things that they're responsible for and should and can help me out when I ask them, and they won't. And that is, they should have a form, a guidance form for doing petition flyer printing. When people get their petitions printed, which is advertisement leaflets and handbills, they should have a form for doing the tax. And they don't want to help you out with it, even though it's in connection with the committee. I wouldn't mind if it was like for a private business or even for a charity, or for yourself. But when it is for a petition that is to that committee, they should already have a guidance form, so you can take it to a company who's printing your leaflets or whatever you want. And there are some crossovers of printed matter when function expands from being one function to two functions, like magazines and poster magazines. And that would help people, because when it's for a petition, it's not for yourself and it's not for a business. And this is all under, we're paying national insurance for petitions being actioned and governed and operated, and they should just have a leaflet on there for all companies, so the companies know they should do the tax with 0 rating. Also, 38 Degrees, I've got issues with taking petitions down on my YouTube channel, and they're the only things at the moment that I need to get sorted out. I can't actually continue doing my campaigning case because of these issues that are arising, because of people who don't understand the process and procedures properly. And that is, and it's everything is to do with that, the powers of that office in that committee. They are responsible and can act and should act, and I shouldn't have these problems at the moment. I should be getting on with things.